The Waqf Amendment Bill 2024 has become a point of contention in India, sparking debate and discussion across the nation. This bill, aimed at amending the Waqf Act of 2013, has been scrutinised by the Joint Committee of Parliament, or JCP. The JCP's approval of 14 amendments proposed by NDA MPs, while rejecting 44 amendments put forth by the opposition, has further fueled the controversy. This essay delves into the proposed amendments, examines the opposition's concerns, and explores the potential ramifications of this bill. The heart of the matter lies in the proposed changes to the existing Waqf Act. These changes encompass various aspects, including the registration of Waqf properties, the resolution of disputes, and the composition of Waqf tribunals. To fully grasp the implications of the Waqf Amendment Bill 2024, it's crucial to understand the significance of Waqf properties in India. Waqf, an Islamic practice, involves dedicating property for religious or charitable purposes. These properties, ranging from mosques and graveyards to educational institutions and hospitals, play a vital role in supporting the social and economic well-being of Muslim communities. The management and administration of these properties are entrusted to Waqf boards, constituted at both the state and central levels. These boards bear the responsibility of ensuring the proper utilization and preservation of Waqf assets for the intended beneficiaries. The Waqf Amendment Bill 2024 introduces several key changes. One notable amendment pertains to the registration of Waqf properties. The bill proposes extending the 6-month window for registering these properties on the government portal. This extension aims to provide more time for the identification and registration of Waqf assets, potentially bringing more properties under the purview of the Waqf boards. Another significant change relates to the resolution of disputes concerning Waqf properties. The bill proposes replacing the district collector with a senior state government official as the primary arbiter in such disputes. This shift in authority from the district to the state level has raised concerns about potential delays and complexities in the dispute resolution process. The proposed amendment regarding dispute resolution has emerged as a focal point of contention. Critics argue that shifting the responsibility to a senior state government official could lead to a backlog of cases, potentially delaying justice for those seeking to reclaim Waqf properties. Furthermore, concerns have been raised about the potential for political influence in the resolution process. The fear is that shifting the authority to the state level could make these disputes more susceptible to political considerations. Section 5 concerns regarding the Waqf Tribunal. The composition of the Waqf Tribunal, responsible for adjudicating disputes related to Waqf properties, has also come under scrutiny. The bill mandates that one member of the tribunal possess knowledge of Muslim law and jurisprudence. While this requirement seems logical, critics argue that the selection process for this member lacks transparency and could be susceptible to bias. The lack of clarity regarding the selection process has fueled apprehensions about potential political interference in the appointment of tribunal members. Section 6. The opposition's standpoint, a chorus of dissent. The opposition parties have voiced strong objections to the Waqf Amendment Bill 2024, alleging procedural irregularities and a lack of transparency in the JCP's deliberations. They claim that the committee deviated from established rules and procedures, limiting their opportunity to present amendments and engage in meaningful discussion. Furthermore, the opposition contends that a majority of stakeholders who presented their views before the committee expressed opposition to the bill. This disconnect between the stakeholders' opinions and the JCP's recommendations has further amplified the controversy. Section 7. Potential impact on Waqf properties and stakeholders. The Waqf Amendment Bill 2024 could have far-reaching consequences for Waqf properties and the communities they serve. While the government maintains that the amendments are intended to streamline the administration of Waqf properties and enhance transparency, critics argue that they could potentially weaken the autonomy of Waqf boards and erode the rights of stakeholders. The fear is that the changes could pave the way for the misuse or alienation of Waqf properties, ultimately harming the interests of the Muslim community. Section 8. The need for transparency and dialogue. Given the sensitivity surrounding the Waqf Amendment Bill 2024, it is imperative for the government to prioritize transparency and engage in meaningful dialogue with all stakeholders. Open and inclusive consultations can help address concerns, build consensus, and ensure that the final legislation protects the interests of all parties involved. A collaborative approach involving legal experts, community leaders, and representatives from all political parties is essential to arrive at a solution that upholds the sanctity of Waqf properties and respects the rights of stakeholders. Section 9. Conclusion: balancing interests, ensuring fairness. The Waqf Amendment Bill 2024 has ignited a debate about the management and governance of Waqf properties in India. While the government aims to streamline the administration of these properties, it is crucial to address the concerns raised by the opposition and various stakeholders. Finding a balance between effective governance and the protection of minority rights is paramount. A fair and just approach rooted in transparency and dialogue is essential to ensure that the Waqf Amendment Bill 2024 truly serves the interests of all stakeholders and safeguards the legacy of Waqf properties for generations to come.